So why is it that the structure of legal argument has remained unchanged for thousands of years? That's what I'm going to talk about today. So let's go back in time to 466 BC. It's the time of the Greek Empire, and it's the island of Syracuse. Syracuse is off the coast of Italy, but at the time, the Greeks had conquered Italy. Corax was the wise man about town. Some of the citizens of Syracuse have had their property taken away from them. In order to get their property back, they have to go and argue in an amphitheater in front of 5,000 people and explain why they should get their property back from the authorities. They go to Corax and they ask him, what is the structure of an argument? How should we argue our case? And Corax said, every argument should have an introduction, a statement of facts, an argument. The argument should be the principal argument and a response to counter-arguments and a conclusion. Now, by the time the Romans had conquered the world, or at least the Western world, the structure of the argument included an introduction, statement of facts, questions presented, summary of the argument, principal argument and response to counter-arguments, and a conclusion. Anyone who teaches brief writing, appellate advocacy, persuasion in the law knows this is the structure of legal argument, and it has been with us for thousands of years. One more thing we need to know is kind of the way that ancient rhetoricians thought about information or thought about how to make sense out of the world. So let's go back to the Greek Empire and talk about Aristotle's theory of essences. Aristotle believed that all you needed to do to make sense of the world was to put everything in its correct category. Everything in the outside world could be boiled down to its essence, and then you could use a 3-line syllogism to make new knowledge about the world. For Aristotle, it was all about putting things into the right container. If you get into container A, then you can also get into container B. That's the principle of transitivity. If you introduce a new fact and you try to put that fact into box A, Socrates is a man, then that tells you automatically that you can also fit into box B, Socrates is mortal. The thing about this argument structure, this way of thinking, it permeates our legal culture. It permeates our legal culture so much that it could be considered the infrastructure of law. So the deductive syllogism is one example of that. The other example is just the way our legal information has been categorized for us. The Westlaw key number system is a great example. We don't often think about it, but like the wires in the walls and the pipes underground, it is so important to how we make legal meanings and how arguments are crafted. Classical legal thought is also highly dichotomous. So you either win or you lose. You have a cause of action or you don't. You are in or you are out. You are inside the box or you are completely out of it. So this way of thinking, which permeates our legal culture, has been criticized. And one of the areas of criticism has come from cognitive scientists. And the criticism is that this dichotomous, clean category way of thinking is not how we really think. So if we look at a robin, we immediately think bird. And for that, it's quite easy to see how the category works. The category is clear at the basic level. But once we move outside of that basic level and we think about a penguin, yes, a penguin is a bird, but it doesn't really fly, it doesn't live in our backyard, and it doesn't come to the bird feeder. A penguin is less like a bird than a robin. And in this way, categories become messy. And it's not so much a clean, equal box. Just because you're in the category doesn't mean you are at the same level as everything else in that category. Another criticism of this way of thinking has come from scholars who have argued that kind of a formalistic, deductive way of thinking leads to toxic outcomes. And a great example of this is the jurisprudence in the 1800s that perpetuated slavery. If you look at those cases, they are beautifully written, wonderful syllogisms, perfect logic. The only problem is that the containers being used is the category of property rights. We're not talking about humans. We're not talking about human suffering, civil rights, human rights. Those were not even part of the equation. And in that way, categories and the way you structure them into a syllogism are a powerful way that you can perpetuate injustice. So with all the criticism out there of this kind of thinking, why do we still have it in our legal culture? Why do we still teach our students IRAC, which is essentially the same thing as the three-line syllogism, your rule, your analysis, and your conclusion? One of the reasons is that our brains crave order and structure. So there is a Tumblr website entitled Things Organized Neatly. And it's just pictures like this of things organized neatly. And so our need for structure and order is one reason that we like legal information, the mess of the law, to be organized as cleanly as possible. It's actually an evolutionary thing. Back in more wild, atavistic times, we needed to be able to categorize very quickly. Is that thing going to kill me, or can I eat it? And so that idea of the clean category that we can act upon quickly kind of explains why we like categories so much. Another reason is that when we present information in a clean way, it reduces the cognitive load for the reader. So a phone number is a great example. It's much easier to remember 3 letters and 4 letters than it is to remember 7 letters or 7 numbers all in a row. When we present complex legal information boiled down into 3 lines in an easy to understand way, when we present the gist of our argument first, summarize it, then get into the specifics. These are things that chunk the information and make it easier for the reader to engage with it, essentially making it more persuasive. This is related to the fluency principle. So there are studies out there showing that audiences who are presented information in a fluent way, it's clean, it's clear, they rate the author as more intelligent, and they engage more deeply with the information. So for our students, if we're teaching them to persuade and to write, one of the reasons that we want them to write cleanly and plainly is because it makes it more persuasive. And in this sense, the syllogism, the basic structure of the legal argument, going and providing the general overview before you get into the weeds, all of these things create fluency. And cognitive science explains why this is so effective. So how do I actually teach some of these concepts? I teach categories starting in the first week of law school with the is a sandwich a burrito exercise. Or is the burrito a sandwich? It's based on a real case. There's a shopping center. The shopping center has leased premises to Panera Bread. Panera Bread has negotiated an exclusivity clause. The shopping center has promised not to lease premises to another sandwich shop. The shopping center leases premises to Qdoba, a burrito shop. Panera Bread sues, and they argue, a burrito is a sandwich. You've leased premises to another sandwich shop. I have one half of my class arguing, a sandwich is just what you think it is. 2 slices of bread with filling in between. The other half of my class is arguing, absolutely not. What about the open-faced turkey sandwich? A A sandwich is a filling that sits on top of or is surrounded by a grain-based exterior. So with this exercise, students start to see that categories or rules are not set in stone. They can be manipulated. As we move further into the class, legal process 2 is persuasive advocacy, we get into the idea that you have, as a writer, agency over the way you construct a rule. You can construct a rule narrowly or broadly. The rule is not some verbatim sentence that you have to pull out from the case. As a writer, you are able to craft legal meaning that impacts your client in a beneficial way. And this is huge. This, I believe, is one of the core skills that separates a lawyer from a layperson. As we move on through legal education up into the upper level, I teach syllogisms as it relates to justice. I have my students read the Korematsu case. In the majority opinion, you can easily pull out the syllogism that justifies the opinion that the detention of Japanese American citizens was constitutional. It was necessary for the security of the United States during a time of war. If you read the dissent, you can pull out an equally compelling syllogism that it is not constitutional. Here, I want my students to see that you can use the syllogism to craft a policy-based argument. It's not always just about run-of-the-mill rules from the cases. You can also use the syllogism to create an argument for justice. I want my students to know that categories, deductive thinking, this is an integral part of the law. Categories can become entrenched, but they don't always have to be that way. For instance, property and contracts used to be the same category. Back in the 1700s, they were part of the same doctrine. They eventually became separate. So for students working with the law, thinking about creative ways to redefine categories and reimagine them, this is what I want my students to do. Thank you.